So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too cool to button your jumper up, just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again. So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do, okay? The agreement on these were for a 10-year deferred on those 2 aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports? Or the report? Are there any additions or corrections?
None of them are good. Optimistic.
So I don't know about all this. Not real sure I want to go along with this plea agreement. Mr. Johnson?
Yes, ma'am. I promise that I'll do right this time.
This time?
Yes, ma'am.
You have been in trouble for breaking into people's cars, stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing. I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, and you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when you're lucky you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I can't afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better.
Yes, ma'am.
You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to.
That's an understatement, don't you think?
Yes, ma'am. I understand.
I appreciate too that you're being honest with me today.
Yes, ma'am.
But I have to look out for the community as
Yes,
much
ma'am.
as, you know, I kind of have 2 things I've got to do here. Figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this and I need to get my stuff together. And
Yes.
do you have people, I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, ma'am. Listen, I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over that. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you,
Yes, ma'am.
especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right?
No, ma'am.
Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily,
Yes, ma'am.
and find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here. Okay? And so here's something that's very important though. You have a handful of write-ups in our jail.
Yes, ma'am.
I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF.
Okay. You said how long ISF?
It's a 90-day program. Okay? So you've got two separate things going here. Now you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker. All right? Good luck. Take advantage of this opportunity. What? Oh, okay. Gerson Mendoza. Mr. Lewis. I'm sorry, I didn't realize you were here. Y'all let us know as soon as those are ready, and I'll try to get you out of here. And Ms. Burge, if you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, ma'am.
Thank you. Good morning. Are you Gerson Mendoza? And this is cause number 250304. Will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Mendoza, you're charged with the first-degree felony offense of aggravated robbery from December 1st of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with?
No.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis, with the interpreter?
No.
And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, that you're waiving any right to appeal?
No.
And it looks like the agreement that you reached is for a 10-year deferred probation, a $1,000 fine, and you would be required to follow all of the rules of probation. Is that your understanding?
No.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yeah, ¿entiendes?
No.
Yes, ma'am.
And state tenders number 1,
No objection, Judge.
it's admitted. Is there any evidence that Mr. Mendoza is not competent?
No, Judge.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing so we can get a pre-sentence report done that'll give me more information about you and your case, and then we'll come back later for sentencing. What is the state's position with regard to a bond based on the nature of the?
History is young age, he's 18 years old. Just was several classmates that that was less,
I can't hear you.
I think he was less culpable than the other defendant. There's a co-defendant in this case.
I'm not going to change the bond based on his age and the nature of the offense. A lot of times what I do in these is possibly ISF or something anyway, just because it had to do with a robbery and a weapon, and he's young. So let's just see what the pre-sentence report says. All right, so you can go back with the bailiff. Thank you, Ms. Bursch. Deontay Reed, it's a sentencing, Mr. Lewis.
Yes, ma'am.
You can tell he does
To a full comprehension.
enough. Yeah.
Yes, ma'am.
Yeah. I'm glad you came because especially with something like this, you don't want there to be any miscommunication.
Exactly.
Good morning. Are you Deontay Wayne? Or Deontay Wayne Reed, I'm sorry. And Mr. Reed was previously in court and cause number 240838, entered a plea of guilty to the state jail felony offense of theft of a firearm. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
State has, Judge, I suspect it's something on page 1 of the court.
I-
I have.
Mr. Lewis?
Yes, ma'am, Judge. I've spoken with my client about this, as far as his assessment accountability and for his admission, to this offense. At that time, I could tell you, Judge, after speaking with him, he understands the issue with that, as far as his making a decision to try to get probation, as he's talked about here in the PSI. That this would involve him not just taking responsibility, but being honest and truthful about his plea, whether he was guilty or not guilty. And of course, at that time, explaining it to him that way, he's prepared, of course, to truthfully admit to his involvement in what he did in his offense, which he says he did commit this offense at that time.
So you either did it or you didn't do it. And so if you did it, then you're getting a great opportunity. If you didn't do it, then that's what juries are for, and that's why you would go to trial. So did you do it or did you not do it?
I did it.
Okay, and do you want me to go forward with this?
Yes, ma'am.
So what happens is you're gonna be spending some time with probation.
Yes, ma'am.
And you've got to be honest with them the whole time you're on probation. They're there to help you.
Yes, ma'am.
And so if you try not to take responsibility and try to diminish things that you're having issues with, then you're going to end up right back in here and looking at going to prison. So it's very important that you're open and honest with them. Do you understand?
Yes, ma'am.
Okay. All right, then, any reason not to go forward with sentencing?
Not real estate.
All right, Mr. Reed, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that. You'll be on probation for $1,000. You will also be ordered to pay
Is that probation for 5 years?
5 years.
What did I say?
For $1,000.
It's been a long morning. Y'all are all like, what is happening to her? Okay. You're going to be on probation for 5 years. You're going to be ordered to pay a $1,000 fine. I was reading faster than my mind was going. You're ordered to pay $1,500 in restitution also, and to follow all of the rules and conditions of probation. If you do that, this is a good opportunity for you because you're going to be able to serve that 2-year sentence while you're out on probation instead of in state jail prison. The other side of that, though, is if you violate any condition of probation, you'll be right back in here and you'll be looking at that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
There's going to be, I want you to get your GED is going to be ordered for you to get your GED. That's to help you so you can get better jobs and do better things. There will be mental health treatment if you need any kind of issue. Everything that they offer you and tell you you need to do is ordered. And so you're required to do that, and it's all meant to help you. Okay. So you're welcome. And so I'm handing you somewhere the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Yeah, I think I'm out of my words. I think I ran out of words the very first thing I did this morning. That's the whole problem today, is that got me off my game. Desmond Jones, Mr. Lewis. Because I keep thinking about it and how I'm gonna handle that. I'm not done. I don't think I'm done. I could tell as soon as I did something, everybody's face went. What's she talking about? Good morning, sir. Are you Desmond Jones? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Jones, in cause number 250610, you're charged with the state jail felony offense of unauthorized use of a vehicle. That's from March 28th of 2025. And how do you plead to that charge? I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle, sentence you in accordance with that agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. Ms. Holmes, you've got Tilia Mills.
Yes, ma'am.
Thank you, Mr. Lewis. Have a good day.
Thank you, Judge.
You okay over there? Good morning. Are you Tilia Mills?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Mills, in cause number 240549, you're charged with the state jail felony offense of theft with previous convictions from November 4th of 2023. The indictment alleges you were previously convicted of theft July 14th of 2022 on 2 different cases on that date in Montgomery County, Texas. And then after those were final, you were convicted 2 times on June 21st of 2023 of theft in Harris County, Texas. And how do you plead to that charge?
Guilty.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Mills is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am. You can go back with the bailiff.
Okay, this one.
Renesia Segura, Ms. Holmes?
Yes.
I feel like there's just lots of work. Oh, this is an NTRP. Good morning. Are you Renesia Segura?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Segura, in clause number 231869, I have a motion to revoke your community supervision. Shows that you were placed on probation July 29th of 2024 for the offense of theft of property with previous convictions. And that was a 2-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of theft in aggregate amount January 29th, 2025 in Harris County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, and that you were at a location, you were arrested at a place where a crime had been committed with individuals who had previously been convicted of crimes. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
Give me a minute here.
Judge, I'd reviewed some of the Harris County offense material. She was essentially an accomplice while other people were committing theft in this instance.
I'm gonna real quick look back at the pre-sentence report to see that, all that, the criminal, how many we've got.
A lot, and I won't say it.
Oh, yeah, no. I'm not accepting this. My notes, I sent you to ISF already. And my note says it was a cap of 15 months at that time. And I wrote on here that you deserved the whole 15 months. And it's like Mr. Lewis was your attorney at that time. And he and Ms. Holmes are both doing quite the job for you. But 8 months with 7 felony convictions for theft, 5 more arrests, plus this one, and now you've been arrested again, is not something I'm going to accept. Absolutely nothing less than the 15 months that was the cap in the first place. So it's either something like that, or it's an MTRP. I don't have to, y'all go talk about it. I'm deleting the paperwork. All right, go back with the bailiff. If y'all come up with something today, then that's fine. If not, we'll, but I deleted it. You'll need to redo something.
Oh, I'll say I told you so when I go down the offer. Can I have a note on my file that I argued for the full 15?
Well, then I don't, then why? Then throw it back in my face.
Well, I didn't want to on this one.
Well, it deserved
They
it
gave
though.
her- They gave her like 30 days time served.
But that's Harris County. They give 30 days time served on aggravated robberies.
They do like,
I mean,
they do 45.
that doesn't count. That's not,
They do 45.
absolutely. When there's something like that, no way. Okay, Jalen White.
So the offer, we're unagreed on the type of probation. So
Okay.
State's offering straight, we're asking for deferred.
So it is an agreement with regard to probation, just not the type. Okay,
Yes,
thank you. All right, so are you Jalen White? And will your client waive the formal reading of the
He
indictment?
will, Your Honor.
Let me get to it. Mr. White, in cause number 24-0038, you're charged with a third-degree felony offense of possession of a prohibited weapon from July 7th of 2023. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am. I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it's my understanding that you have reached an agreement that I would give you a probation, but it is not agreed to the type of probation. Is that your understanding?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. White is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Ms. Holmes. She'll present it to me on your behalf when we come back. Did you have something?
Yes, Your Honor. I anticipate there will be at least one witness, a short witness at the sentencing.
Okay.
And a video as well, a short video. I don't know if we just need a little bit more time than ordinary.
Let's just, we'll do it at 11.
Okay.
That way, y'all have plenty of time.
Yeah.
And, Your Honor, since this is a probation offer, although we're unagreed on the type, would the court consider reduction of bond?
State's opposed to that, Judge. The alleged weapon that was possessed by this defendant was outfitted with a Glock switch. Actually, I don't want to speak. I know it was outfitted with a Glock switch. I think there was also 2 weapons that was involved in this entire occurrence.
Well, let's see. How old are you, Mr. White?
23.
There were 2 weapons involved, one of which was outfitted with a Glock switch, Judge.
Typically, on a probation offer like this, I would be inclined to do that. However, with the type of offense and the age of Mr. White, there's the possibility, like I have been on a lot of these young ones, that I will consider something like ISF, depending on what that pre-sentence report shows. And based on that, at this time, I'm not going to reduce that bond. Okay, you can go back with the bailiff. On Segura, I'm printing a PC on that Wilkinson. And is there an order for the bond, for the All right, are you Dylan Wilkinson? And Mr. Wilkinson is charged in cause number 250260 with deadly conduct, discharging a firearm. And Ms. Holmes has filed a motion asking that I reduce the bond, which is currently set at $100,000. There was a non-appearance, is that correct? A bond forfeiture for non-appearance.
And that's what we'll address here, because he bonded out in Smith County, so he actually did post a bond, but Jefferson County apparently didn't get word of it. So he was in custody in Smith County, posted bond, but still had the warrant here. And so when he came to Jefferson County, he was rearrested. And then it was set at 100,000.
But I show there was a bailiff's call. There was a court date set. Yeah, there was a court date set that, on May 19th of 2025. There was a court date and a bailiff's call, and he was not here.
Per the bondsman, after I had spoken to her, she said, basically, she told me on the ISTC phones up there at the jail when I got arrested this time, she said that Jefferson County was highly pissed I had gotten, I was able to make bail, and that for 4 months that they had not known that I was out on bail. And then she said I needed to take care of the stuff in Jefferson County and that she was no longer my bail bondsman. And that was the last time I spoke to her.
She doesn't get to say that, so,
But
but that's why you probably didn't get
that's what she
notice of it. This is from a Big Green Bail Bonds
That's the woman that I had spoken to.
in Tyler.
Yeah,
Okay,
Because I wasn't sure
yeah,
why.
that's Smith County.
I wasn't
Texas.
exactly sure why I was rearrested again. And she never really could give me a straight answer.
and she never told you about a court date.
No, ma'am. And you're saying I had a court date on what date you said?
May 19th.
This one might have been the court date.
What were you arrested for in Smith County?
The charge from here.
Just that he turned himself in Smith County, thinking he posted the bond, but
Okay.
I don't know.
And the initial bond that they set, I guess, did
It was
they
only
set it or did I?
10,000.
They said it, there.
It was 10,000. Let me read this real quick. They also did file an AFRS to get off the bond. But the bond forfeiture overrode that, so that might be why she. For everyone's information, I'm reviewing the probable cause affidavit, which obviously makes me have some concern on what the allegations are that you did. So where do you live?
I'm going to be staying with my mother.
With your mom?
Yes, ma'am.
Where's that?
1 street over for Brinkman Drive in PA.
In Port Arthur?
Yes, ma'am.
What is the address?
3965 13th Street.
396513.
And what is your mom's name?
Monica Osman.
What's his last name?
Osman, Ozmun.
Is there any criminal history that you know of?
There's a misdemeanor DWI conviction and a very extensive juvenile history from Henderson County.
Okay.
Several adjudications for unauthorized use of a motor vehicle and burglary vehicle.
And I believe those were over 10 years ago.
It can't be that long ago because he's only,
He's 25.
okay.
I think they're
Yeah.
around 2015.
Okay.
And the complainant, is my understanding, she doesn't live here. She lives in the reports that state she lives around like the Dallas area, like Kemp, Texas, where that, I think that's up near the Dallas area.
Okay.
There's 2 complainants.
Yeah.
Oh,
There's one here and one there.
Yes, Your Honor.
but the girlfriend lives up near the Dallas area.
Haley Murph.
Yes, ma'am.
When's the last time you had contact with her?
It's been at least 9 months to a year. I haven't spoken to her since well over last year. I don't know whereabouts, I don't know where she's at. Last time I heard anything, someone had told me that she was engaged and moving to Colorado.
Second. And do you know this Samantha Grant?
No, ma'am, I've never met her before.
Mr. Nichols, what's your position?
Whatever the court decides as far as the bond, it just has to be sufficient to make sure he appears. I'll let the court know there's some cooperation issues with the girlfriend of the victim, but I have seen nothing to concern the other victims. So I intend to push this case forward, Your Honor.
Okay. All right, so here's what I'm going to do. Mr. Wilkinson, I'm going to grant the motion to reduce your bond. I'm going to reduce your bond to $30,000. If you make that bond, there are several important conditions of it. The first is that you have absolutely no contact, no communication in any way. That's obviously in person, but it also means through social media, sending messages through other people, anything like that, with either Haley Murph or Samantha Grant.
Yes, ma'am.
Also, you are going to be ordered as a condition of that bond to live with your mom, Monica Usman, at 3965 13th Street, and that is the only place you can live. You cannot move unless you ask my permission. You're also going to be required to wear a GPS monitoring device at all times and remain in Jefferson County unless you have my permission. Do you understand that as well?
Yes, ma'am.
All right, any other conditions or?
I think that'll do it, Your Honor. Thank you.
Yes, ma'am, if you can.
Okay, so he does have a job that requires travel, Your Honor. How would that work as far as, do we need to
I need
contact the
this.
court?
Yep. I want specific information about, you need to get that to Ms. Holmes. And so if you make that bond, a couple things will happen. One, if you make the bond, you need to know now that you will be required to at least try to hire your own lawyer. So that's something you'll need to keep in mind. Ms. Holmes will stay your lawyer unless that happens. But as soon as you get out, if you have a job that requires travel, you need to let her know, employer, get something in writing, where you go, things like that. She'll get it to me through a memo with Mr. Nichols involved in it, and then I'll say yes or no to that. You cannot leave unless you have my permission, so you've got to stay in touch with her. She gets to me, and then you'll see if you, and I mean, we want you working. I just need to know where and what the company is and all that kind of stuff. Okay?
Yes, ma'am.
All right, you can go back with the bailiff. All right, and- yeah, okay. Okay, Mr. Nichols, Mr. Franklin, on Juan Sanchez. Good morning. Morning. Good morning.
Good morning.
You come on.
All right, this is cause number 1830854, and sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests. And then I would approve you guys giving whatever records are requested within reason. If you have, I don't know what would necessarily be any type of work product that would not be discoverable, but if you think that there's something that is particularly not discoverable, let Mr. Nichols know that, Mr. Nichols let me know that, then we could worry about maybe a motion to compel and whether or not I think those things are or are not. But lab results, of testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the.
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
Sure.
I kind of agree with
So-
you. I don't want to subpoena directly to those agencies was the proper way to do this. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May.
Right.
I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards
Right.
getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Let me look at the motion itself. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation, and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay,
And
I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through. But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence. And
Yes, Your
so
Honor.
that's not the way we're going to do
the
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah,
there was something that the court was ordering her not to turn over.
I don't think on this list that there are, I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, or do you have any concerns you want
If there's,
to make the court aware of?
Your Honor, just with the clarification of, our departmental chronologicals, which include, anything that pertains to the case that happened, chrono telephone calls, auto-generated, appointments, reminders, office visits, drug tests, anything that we enter into the system. But those are the chronologicals through the probation office, as well as releasing of the jail logs, his sex offender verification, interlock reports, because those were not listed on the subpoena, as well as the offense report through DPS, which was released to me and my under a supervision officer. So just to clarify, as to those items specifically being released that were not listed with the exception of the offense report.
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronologicals.
Well, and these aren't, the reason you didn't get any of those is because those aren't his, they're theirs. And so they're not, I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out though, I think whatever Mr. Nichols, y'all get together, obviously offense report, if y'all have the offense report and you don't even have it, then you need to get,
Right,
that's great. Everybody can get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is, I don't know that there's anything I can think of that would be,
Unless, I guess
Not-
notes may be work product, but I'm not real,
that's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes. And so I don't know that that would
I
be an
would object to
issue.
that, Your Honor, on the grounds that it's not attorney work product. It is merely work product of an employee and it is discoverable and relevant to the case.
And that's what I just said. You seem very frustrated and I'm not sure why. I don't know,
I'm confused why there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
this is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And the
Your-
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here, or sitting here saying that I agree with you and you're still being argumentative even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in what, a couple weeks or so? Fine with that?
Yeah, that should be fine, Judge. We'll be able to
Okay.
get everything scanned in and provided through the portal.
Perfect, thank you. All right, y'all are all excused.
Visits be needed?
I'm sorry? No, ma'am, if you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're gonna have to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations, then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay?
Yes,
Good?
Your
All
Honor.
right, thank you, y'all.
Thank you.
Is she back there with, is Brittany back there? Which one? That's on Mr. Miller.
Thank you.
Good morning. Thank you for coming real quick. We'll at least take care of Mr. Miller so they can get him. Okay. Mr. Coleman, we're going to take care of Mr. Miller. It's a competency.
Okay.
All right, this is cause number 241916. And are you Edward Miller? Good morning. And so Mr. Miller was evaluated by Dr. Hamza for competency to stand trial. I received that report dated June 26th of 2025. The finding in that report is that Mr. Miller is not competent to stand trial. Is there any other evidence with regard to competency? Ms. Holmes?
No, Judge.
And then at this time, I am going to find that Mr. Miller is not competent to stand trial, that inpatient treatment is required for competency restoration. Order you to the appropriate facility. This is just to get you some help, Mr. Miller, okay? And we're going to get you some help, and then we're going to get you back in here. And it'll be for a period of not to exceed 120 days from the date that he gets to the appropriate facility. All right, you can go back with the bailiff.
I just want to remind you, we added that on the guy from yesterday with the flight, Charlie.
Oh,
It's not on the docket anywhere, that's why.
and what was it said?
It's just,
An announcement?
yeah, but
What?
yeah, that land underpaid.
Oh, okay. But is it on the, is it going to show
Yes,
up
ma'am.
here?
You may have to refresh your calendar, but it's, yes.
Okay, all right.
Judge, if I just use this case, into his,
If, it goes,
does it still need to be a case pending for him to remain convicted?
yes. So the only other option would be to go through the civil, go through a civil commitment would be an option. And so if you get that done, the case can get dismissed, and then he can go a different route. But you have to get with your people on how to do that. I know Ms. Malfino's done it on some, but it,
This was just not, I don't want to scoop, mess with his ability to get treated.
if it's, obviously there's some issues that need to be taken care of. So perhaps we get the initial competency restoration done and then do it at that
I'll
time.
make a note on file.
Yeah. Yeah, how did that feel coming
You reach down deep.
Oh my gosh, I got so mad that I'm shaking still. Like, I haven't been that frustrated in a long time. Mr. Kimler, you have Reagan Howard. I just don't do well with that stance.
Mr. Smith and I are getting along there.
Thank y'all very much. Appreciate that.
There's not a bit of old friend.
That's an interesting way to start the morning.
On this one, I've just been waiting for the motion to be true. She'll play true or not true, then I'll ask her mom. And she did have an email of hers.
Good morning, ma'am. You're Reagan Howard.
Yes, ma'am.
Ms. Howard, would you please raise your right hand? Best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Let me get this. And she's just going to plead to the motion.
Yes, ma'am. Yes, Your Honor, and I get it updated to the sign, and Mr. Smith, there may be evidence he wants to put on right here.
Okay. All right, let me get this pulled up. Ms. Howard, in cause number 2239924, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2024 for the third-degree felony offense of deadly conduct discharging a firearm, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department October 7th and November 1st of 2024. And is that true or not true?
Can you repeat that? I'm sorry.
The dates were October 7th and November 1st of last year, 2024, that you did not report. Is that true?
That's true.
Okay. Count 2 alleges that you're behind in your court-assessed fees. And is that true or not true?
That's true.
Count 3 alleges that you also failed to report June 27th, August 21st, and September 24th of 2024 to the probation department. Is that true or not true?
That's true.
Count 4 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
That's true.
Count 5 alleges that you failed to immediately report your contact information as ordered to the probation department. Is that true or not true?
That's true.
Count 6 alleges you provided a urine sample August 27th of 2024 that tested positive for alcohol. Is that true or not true?
True.
Count 7.
Tied to the same UAPH.
So count 7 alleges that on that same date of August 27th of 2024, you also tested positive for cocaine. Is that true or not true?
That's true.
And then count 8 alleges on that same date, you also tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 9 alleges that you did not provide verification of performing the community services required. Is that true or not true?
True.
Count 10 alleges that you did not provide verification of entering and successfully completing the anger management program. Is that true or not true?
Not true.
Not true. I didn't get assigned to anger management.
Okay. Count 11 says that you did not submit to alcohol or drug screening September 9th and September 16th as and then apparently you had possessed a device or an object for the purposes of providing a fake specimen. Is that true or not true?
Not true.
Count 12 alleges, again, that you're behind in your court-assessed fees. This was done a little bit later, so the amount is more. Is that true or not true?
True.
And then count 13 alleges that you didn't provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 9 and then 12 and 13 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to those counts freely and voluntarily, find them true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, and we'll get an updated pre-sentence report done, and if at that time the state wishes to put any evidence on with regard to counts 10 and 11, they can do so. And then anything that you think is important for me to know at that time, get that information to Mr. Kemmler. He'll present it to me on your behalf when we come back. And this is unagreed.
Stretch
Jody.
out or something.
Okay, all right.
Your Honor, we had asked for a bond. I think if the court would set a reasonable bond for Ms. Howard, and she were able to post that bond, she would be able to demonstrate to the court.
That's
prior to the
denied.
sentence.
I'm going to find at this time it is in the best interest of our community and under the Article 1517 that even though this is a deferred probation, based on the nature of the underlying offense, which is a deadly conduct discharging a firearm, the fact that it looks like Ms. Howard has done pretty much nothing, including not reporting while she's on probation, and when she did test positive, that it is not safe at this point until I have more information for her to be out. So that's denied.
You did have her support letter.
Yes, and I've already received those, and we'll get those to probation as well so that they can be part of that pre-sentence report. Okay, you can go back with the, what's that?
So is ISF off the table?
Well, I don't know right now until we come back for sentencing. So probation will come talk to you, talk to Mr. Kimler. I'll get all the information about what's been going on, and then I'll make a decision when you come back about whether I keep you on probation, revoke your probation, keep you on probation, send you somewhere for treatment. It just depends on the information I get when we come back, okay?
And I'll be out to see you.
Okay.
Okay, you can go back with the bailiff. Mr. Matuska, you've got Von Zell Hall. Good morning. Good morning, you're Von Zell Hall. And in 24-1747, Mr. Hall is charged with murder, and what is the announcement?
Your Honor, at the last setting, I requested some digital media. Since then, Mr. Nichols has done an impressive job of providing most everything I need. Unfortunately, I think some of it hasn't been provided to him. And I've discussed this with him. I'm trying to get a few more items I think are pretty important to this situation before we announce. If I could have a 30-day reset. I think
There was
that would take
some follow-up testing and some documentation that he was asking that I don't see in my file, so we need to find out if it exists, where it is, and things
Okay.
like that, so.
All right, so I'll do one more reset. Y'all can work on that. If there's anything that you can get, obviously get that to Mr. Matuska, and Mr. Hall, Mr. Matuska will be out there, I'm sure, to visit with you once he gets everything to see what y'all want to do at the next court date, okay? All right, you can go back with the bailiff. Thank you.
Yes, Your Honor. Your Honor, I've discussed all that with him already.
I figure. Thank you.
Set for hearing.
We're, impressive. You've done an impressive.
Well, that was a
Can you
good
tell,
thing.
you,
That was a lot, but that's okay. We appreciate that this morning. We're resetting both of Mr. Radford's cases this morning. So, Lenny Lede and Traylon Martin. Okay.
Judge, that Cody Dent, I told you, Auburn was hired on 2 of the cases, and Morgan was on the other. Morgan just said that Auburn's gonna take care of all of them.
Okay.
So I put him in the system, so.
Okay.
Yeah, just refresh your calendar.
Okay.
It's correct.
And we reset Joel's, correct?
Yes,
That's good. I just feel like I need a break. Mr. Rojas, on Anthony Williams. Good morning. You're Anthony Williams? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
What's your signature? Mr. Williams, in cause number 240401, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from December 7th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 7 years. There's a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Sir, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that I can get a pre-sentence report done. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today so they can start that report, and she's sitting at that desk right over there. All right, we'll see you back at sentencing.
Yes, ma'am. Thank you.
Yes, sir. Mr. Rojas, you have Theron Jackson. Good morning, you're Theron Jackson.
Yes, ma'am.
And Mr. Jackson was previously in court, entered pleas of true to counts 1 through 5 in each of his motion to revoke unadjudicated probations. On probation for aggravated robbery, actually 3 cases, an aggravated robbery and then 2 aggravated assaults with deadly weapons, and cause numbers 241324, 1323 and 0883. I've received the updated pre-sentence report. This was unagreed, and has everyone had an opportunity to receive that report and review it?
We have, Your Honor.
Are there any additions or corrections to that report? All
Not from us, sir.
right, Mr. Rojas, you may proceed.
Judge, Mr. Jackson recognizes he's on probation for some serious offenses. And that, you know, in my opinion, it's like he needs help. His main problems come from mental health issues. He's homelessness, he's got lack of transportation, and he's got limited family here in the area. He tells me that when he was first released from jail, he didn't have a place to live, didn't have any transportation. That's the reason for not being able to get to probation department in the beginning. He's been on probation for such a short period of time. he's been unable to get the benefit of the resources that probation has to offer. I understand that's because of his not attending probation. But again, I think that all stems from the homelessness and the lack of transportation and the mental health issues. He is trying to get help for himself. He does have the application to get his government benefits. He's got a contact with someone from MHMR, if he were allowed to stay on probation. He tells me that he has a place to live now. He's going to be living with his cousin who does live here in Beaumont. He is hopeful that he can get his job back at the place he was working for at the barbecue restaurant.
Yeah, that's good.
Hold on.
And of course, that all is going to depend on him actually going to probation. And he tells me now that he does understand that the importance of getting there, he will do everything he can to make sure that he does get to probation if the court were to allow him to stay on probation. And that's what he's asking the court to do this morning, Judge. And at the proper time, I think he does have a statement to make.
Go ahead.
Hello, my name is Darren Jackson. I'm writing this letter pleading for mercy. I started my probation off on the wrong note. Everything I had on probation was in first place. I ended up losing my cell phone and the place that I was living. The people found out that I was on probation and they kicked me out the house. And I didn't have, they kicked me out. I got kicked out of the place I was staying at. And the same night, the police had came and arrested me for some improper, some things that I didn't do. And they said I was under intoxication, but I wasn't, you know what I'm saying? Because they was all fighting and stuff like that. And they put me in jail for one night for intoxication, but they didn't have no breathalyzer or nothing saying that I was intoxicated, and they said I was intoxicated, and they was lying. They was lying on me. They didn't have any record or proof of intoxication. I got to jail and they released me the next day for public intoxication. I reported the next day, the day I was supposed to report. You know how they let you out of jail. You know what I'm saying? At like 3 o'clock. It was raining so bad. It was flooding. And I didn't have nowhere to get there. So I walked. The next day I waited till it stopped raining, and it was unflooded. And I walked to the probation office, and I told the lady that I didn't have my social security card and my ID, and she said she was gonna help me do it. And I was very excited, Judge, for trying to get my GED. I was very excited about going to school, and man, the lady kicked me out of the house where I was staying at, and I had to move in the hotel room. And I ran out of money, and bro, it just all went downhill from there. Yeah. And if you can find any way for me to get back on probation, I promise I'm gonna do the right thing. And you know, I'm a good citizen, and I help anybody I can. I'm a minister of music. I go to church, Solid Rock, Church of God Christ. And yeah, man, I've been trying to stay out of trouble. I've just been running up on hard times. Yeah, I just need a second chance.
Ms. Monfino?
Judge, I'm not unsympathetic to his situation. I don't think it's something that he's just coming in today saying that he's had these problems. I think they've been ongoing. I think that's why we had initially wanted to give him the opportunity of probation so that he could participate in the mental health caseload. Obviously, he's very lucky to have Ms. Ford as his officer, but I have spoken with her several times about this, and she has gone above and beyond just trying to make contact with him to bring him in to say, these are the resources we try to have to help you, and they just can't ever find it. I'm not suggesting that necessarily my position is revocation, but my position would be, Judge, if the court gives him this opportunity, he does not take advantage of it, and he does not do what Ms. Ford needs him to do, that the court orders him to do, that my recommendation would be significantly higher than it would be today on revocation based on the underlying
there's doesn't, you probably haven't even had enough time to know, I guess, my question, Ms. Core, would be, if I continue him on probation, would something like cognitive track of ISF be
Yes, ma'am.
helpful, or that, or either special needs safe P? Which one do you think would be more appropriate to help him get a good start before he gets back out?
I would think very highly of his special needs safety for him.
Okay. Okay. I mean, Mr. Jackson, everybody wants you to be successful,
Yes, ma'am.
but you're the only one that can make that happen.
Yes, ma'am.
You have all the resources. Ms. Core wants to help you. Probation has all kinds of things to help you, but you have to, they're not going to come, she's not going to come find you.
Yes, ma'am.
So, if I give you this opportunity today, you're going to go get some help in custody. Listen, and when you're out though, and when you're finished with that treatment,
Yes, ma'am.
it's going to be your responsibility to go where you're supposed to go, to let her know where you're living, and she's not going to go try to find you. You don't show up, then you're going to be back in here and we will not be having these conversations. Today, I could send you to prison for the rest of your life for violating your probation. Right now, today, for life, for 50 years, for 30 years, for 20 years. An aggravated robbery and 2 aggravated assaults with deadly weapons. You should probably be going to prison. So you need to understand that this is it. There's no second chance. This is your chance. All right? So I'm going to find that you entered your pleas of true to counts 1 through 5 in all 3 cases freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probations and find you guilty, but I'm not going to do that. I'm going to continue your probations in each of your cases. I'm going to order in each of your cases that you enter and successfully complete the special needs track of SafeP. That's going to give you all kinds of help to make sure when you get out, you're ready to go and you'll be making better decisions. You won't have any issues, hopefully, with regard to any type of drug or alcohol abuse, and you will also have aftercare, a place to live, and things like that. So you're going to have what you need, and it's going to be up to you. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Moore. Ashley Faye, Mr. Rojas. Good morning.
Judge, we think we can do this. She has 3 prior state jail felonies on the same day. They're not sequenced, but I think we can still do a third degree.
Yeah, they don't have to be sequenced. Only regular ones to make it a second degree have to be sequenced.
We're worried.
That's our old drug court days, Kobe. You should remember that.
But I looked at them when they're all the same day. I went to draw that.
Yeah, I remember that from those days. Okay, so she's gonna go. Let me say this the right way.
The audit sheet's been emailed, Judge.
Thank you. Good morning. Are you Ashley Faye? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Faye, in cause number 250355, you are charged with the state jail felony offense of credit or debit card abuse from October 16th of 2024. Your indictment alleges that you were previously convicted of theft, a state jail felony, March 15th of 2019, in 3 different state jail felony cases of theft on that same date. And how do you plead to the charge? And are those prior theft convictions true? Answer out loud, please. Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you not understand something?
No, ma'am, I kind of wanted to ask for probation.
So this isn't where you do that. Y'all have negotiated with Mr. Rojas. Mr. Rojas negotiates with Mr. Hoffpower. They do all of that. I don't get involved in that process. So there's a couple of things you can do. You can, go ahead, Mr. Rojas.
So we did have an offer for a cab, Judge. We talked about that, and this is the one that she chose. If you're having second thoughts, we can talk about that some more.
Do you want to go talk to Mr. Rojas about that cap? The cap would be pleading open to me, where I could give you time in prison, I could give you probation. It would depend on all the information that I was given at a later hearing for a sentencing hearing. If you want to do that, then you do want to do that. I think you're going to have to do the unagreed, the different.
Right, that's different paperwork.
No, you're not. With everybody's permission, I can make those changes on this.
Yes, ma'am.
What is it, cap of what?
Cap of 5.
How do I? No, it's not. It's writing with it. See, I'm just scribbling on it. So on the agreed punishment recommendation page, I am marking off the cap of 5. And then I think that's really the only thing that needs to be changed. Okay, so then let's go back. The agreement that you've reached is for a cap of 5 years. And I want to make sure you understand, it sounds like you've gone over it with Mr. Rojas, that what that means is that you're leaving your punishment up to me. As long as I give you 5 years or less, I can consider probation, you cannot appeal. Do you understand? And you have an absolute right to have a jury come in and determine if you're guilty or not. You can leave your punishment up to a jury. If we go forward this way, you're waiving that right. And is that what you want to do? Right. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Fay is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a report that'll give me more information about you, your history, your cases, and then we'll come back for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff. Yes, ma'am. Do you have anything else?
The add-on,
Oh, okay.
can you see it, Leonard?
Give, that's for a bond.
That's the one from, last week, straight probation. Hold on just a second. Let me pull it up.
When she was ran on a new case, she's on strict probation, and Judge DeRuin sent you an email asking.
Of course it did. Sure, I remember that.
There's not a motion filed or anything. I think you just set this on your own. I think you. She's got a baby at home.
Oh. Yeah, and. Okay, but nothing was filed. She just made the request of, let's get Janicia Leonard out and I'll just put it on the record, since they. I just decided to, well, and what went on, I don't know if you know, so last week I received a message
Mr.
from
Rojas caught me on the way in, the baby,
Judge, yeah,
We sure
Ruin.
that the jail has a policy in place for that, maybe the pump.
I'm not concerned about it necessarily. I just wanted to put something on the record because she made, I guess, enough impression on Judge DeRuin. And so even without a motion, I just wanted to at least put some stuff on the record. And then obviously if at a certain, I'm not going to set a bond today, but I'm going to explain where we are, why there's not a bond. And then if you want to file something and we have time for a hearing with some specific information, once you kind of get, then I'll reconsider it. But let's just. Yeah, well, there's that. The only thing, the issue, one of the issues I have is the new case, it's from 23. And so actually I might consider a bond just because if she hasn't been arrested since 23. Let me look
If I
at.
could just have, I mean, I would want 3 days to prepare, but if.
We can reset it for next week. I just want.
If you want to do it today, I'm not opposed to doing it today. My argument would be, Judge, it follows the same pattern.
Yeah, I just, the length of time, I want to know if she's been doing well on probation other than that. That's one thing I would like to know. And so I think let's reset it for next,
We can reset and I'll follow up.
let's do that. Let's reset it. Tell Sharon, never mind. Let's reset Miss Leonard for next week. And then I would like to have, I think Miss Core already left. Miss Core was her, that's okay. For next week, if she can be here, just so that I can, because of the length of time of that new offense allegation and when it was indicted, I think I'll consider that, and that'll give you time also, Mr. Coleman, to see what's going on and what we can do. All right, thank you. Okay. Mr. Samuel, you have Cody Dent.
Yes, Your Honor.
Good morning.
I'll discuss that, so I'll be filing that afterwards. After court.
Okay. If you're requesting, make sure if it's, since you're hired, you'll have to do an affidavit of indigency if you're asking the county to pay for anything.
I will.
So make sure you attach that with it when you
Okay.
do it. Good morning. Are you Cody Dent?
Yes, ma'am.
And Mr. Dent is on probation in two cases, 13-17772 and 22-41052 for the offenses of obstruction or retaliation and theft of property. Those both have motion to revoke pending. And then there is a new allegation or new indictment in cause number 250807 of burglary of a building. And Mr. Samuel,
Yes, Your Honor, I've been hired to represent Mr. Dent. I went out and visited with him this past weekend, and I've also spoken with him this morning. And as a result of my evaluation and talking with him, I believe it's merited to have someone appointed to give a professional evaluation. We realize that he is on probation. I realize there is a new charge. This is our first setting. I've not had an opportunity to complete discovery, but I think upon getting the information from discovery, and if we can set for bond hearing at a later date, maybe next week, if possible, we believe that the results of that evaluation will show that there's possibly some alternatives that are available.
So it's set for bond hearing today on those motions, but you want some time to get up to speed on that other case? You want me to put that off, just hold it?
Yes.
Okay.
Yes.
All right.
At least until next week. I'd like a quick turnaround because right now there is no bond. And
Right,
he needs to get assistance.
okay. An evaluation won't happen in a week.
I understand.
Okay, so but you still think give you a week to get up to speed,
Correct,
bond hearing next week,
correct.
and then I'll look at your motion for the evaluation. We'll take care of that.
And I
Right.
talked with the prosecutor.
Okay. We'll reset it. How's next week? Are we?
Yes. No,
We're good? Okay, we'll reset it for 1 week, for a bond hearing on those two motions.
Right.
Thank you.
Thank you, Your Honor.
When you're finished, I'm saying. The city does need to fill out. Here's an affidavit.
Mr. Lewis, on Justin Franklin,
I just wanted to-
So, okay.
good morning. Are you Justin Franklin?
Yes, ma'am.
And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, I'm Mr. Franklin, I understand that the plaintiff witness had been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Will you call the name Kayla Davis, please? Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something
Go
on the
ahead,
record?
Judge, if you would
Okay.
just mind swearing your.
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record?
He's Taylor Davis.
And Ms. Davis, what is your relationship to the defendant, Justin Franklin?
He's my husband.
Okay, and how long have you all been married?
We got married in January.
In January? And you know what we're here about today, right?
Yes.
The aggravated robbery that he's alleged to have committed against you and your children, right?
Yes.
Where he held you all at gunpoint and stole your purse and wallet, right?
He didn't hold us in gunpoint and he didn't steal my purse nor wallet.
Did you tell the police that that's what happened?
No, ma'am.
Okay, so if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office, asking that the case be dropped, correct?
Right.
You've come in and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state, correct?
Yes, I have.
Are you in fear of Mr. Franklin?
No, I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety?
Yes, I do.
And that's what you want me to do?
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to
Judge
allow me
West
to drop the case?
To drop the case.
All right. All right, you can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I have both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right, if that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff. Yes, ma'am. Mr. Parker, you have Tracy Haynes. Good morning. Are you Tracy Haynes? And this is cause number 240514. I'm going to take judicial notice of the court's file. Mr. Haynes was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from them dated June 23rd of 2025 with that report from Dr. Samantha Guzman with the opinion that Mr. Haynes has achieved competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No.
Then at this time, I will find Mr. Haynes is competent to stand trial. And will he waive the formal reading of the indictment, Mr. Parker?
Yes, Your Honor.
And are we going on count one only? Hold on, let me get it correct. All right, Mr. Haynes, in cause number 240514, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of obstruction or retaliation from February 3rd of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
The stuff on the computer.
The stuff on that computer tablet, did you go over that before you signed it with Mr. Parker?
Yes.
And do you understand those documents that you signed? Speak up, please.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So if I follow your agreement, you can't change your mind later. Do you understand?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. Speak up, please. When you're answering, I need you to speak up. State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your plea of guilty to count 1 freely and voluntarily. Find that you're mentally competent again and that you understand the nature and the consequences of this plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation, and sentence you in accordance with your agreement to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Mr. Parker, you've got Jack Hooper. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. Yet, he's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. He doesn't have, well, I mean, he doesn't have any new cases. His violations are the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. We're asking that, I think he should be given some consideration for that. We're asking for a 3-year sentence.
So you stopped reporting May 5th of 2021. So didn't really report as
I apologize.
directed.
I misspoke that.
You've been an absconder since 2021. Ms. Malfino?
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount, but I would obviously recommend revocation, whatever amount you think is appropriate if we need to revisit that issue.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time, I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Jeremiah Johnson. Sentencing.
This courtroom hearing takes a serious turn as the judge deals with a defendant facing possible consequences in 2 separate deferred probation cases. The defendant had previously been placed on 5 years of deferred probation for possession of a prohibited weapon in one case, and 5 years of deferred probation for possession of marijuana in another. But now, both cases are back before the court because prosecutors allege that he committed new offenses while still on probation. The allegations include money laundering involving between $2,500 and $30,000, as well as using a wrong, fictitious, altered, or obstructed license plate. The judge explains that before making a final decision about whether probation should be revoked, the court needs to carefully go through the allegations and determine how the defendant responds to them. The defense attorney, however, raises a major issue with the evidence behind the new charges. According to the attorney, the case began after a canine search of the defendant's vehicle, and after reviewing the available discovery, the defense believes there may be serious problems with that search. The attorney says more information is needed about the canine, including records involving the handler and the dog, before the allegations can be fully challenged. The judge does not rush to a final decision. Instead, the court recognizes that the defense needs time to investigate the canine issue and obtain the necessary records. The judge points out that if the new allegations cannot ultimately be proven, that could significantly affect what happens in the probation cases. At the same time, the judge explains that the standard of proof in a motion to revoke probation is different from the standard used in a criminal trial. That means the court must carefully examine the evidence and the defendant's probation history before deciding what consequences, if any, should follow. When the defendant is formally asked how he pleads to the allegations, pleas of not true are entered to the new offenses in both cases. The judge then decides to reset the matter for a future sentencing hearing and orders an updated pre-sentence report. Because the cases involve separate alleged offenses and different probation matters,